भारतीय नागरिक सुरक्षा संहिता 2023. What Section 231 says? Section 231 of the Bharatiya Nagarik Suraksha Sanhita 2023 deals with the rights of an accused person to receive copies of certain legal materials in specific cases. When it applies. This section applies when a case has been started not on a police report, e.g., a private complaint or other origin, and it appears to the magistrate under Section 227 of the Sanhita that the offence is triable only by the Court of Session, a higher criminal court. What the magistrate must do. Once the magistrate finds that the offence should be tried by the Court of Session, Section 231 requires that the magistrate must immediately give the accused free copies of statements recorded under Section 223 or Section 225 of all persons who were examined by the magistrate, and certain documents that are relevant to the case. These copies help ensure that the accused has access to important evidence and statements before the case is sent to the higher court. Format of delivery. Copies provided free of cost to the accused. Electronic copies are also considered valid, meaning sending them digitally satisfies this requirement. Why this is important? This provision is meant to protect the right of the accused to a fair trial by making sure they receive the same statements and documents that the prosecution has, especially in serious cases that will go to the Court of Session for trial. What Section 232 is about? Section 232 of the Bharatiya Nagarik Suraksha Sanhita 2023 deals with how and when a case is committed to the Court of Session, a higher criminal court, if the offence is triable only by that court. It is similar in purpose to the old Section 209 of the Code of Criminal Procedure 1973, but under the new BNSS structure. In simple English, what it says: when a case has started, either on a police report or otherwise, if the accused person is produced before a magistrate and the magistrate finds that the offence is so serious that it can only be tried by a Court of Session, then the magistrate must commit the case to the Court of Session. Before doing this, the magistrate must ensure that all relevant procedures in Sections 230 and 231, like giving copies of police reports, witness statements, and documents to the accused, are complied with. What the magistrate must do. Under Section 232, the magistrate must commit the case to the Court of Session, send the full record of the case, including documents and articles to be used as evidence, to that court, inform the public prosecutor that the case has been committed, time limit to complete the process. The magistrate should complete these proceedings within 90 days from when the court took cognizance of the offence. The period may be extended up to 180 days if there are written reasons recording why more time is necessary. Why this section matters? Section 232 ensures that serious offences, those requiring trial at a higher court, are transferred quickly and properly with all the necessary materials so the accused and prosecution can prepare for a fair trial. It also clarifies the duties of the magistrate in such situations. Section 233, Opening Case for the Prosecution. What this section is about. Section 233 explains what happens when a criminal case reaches the Court of Session and the trial is about to begin. It deals with the first formal step of the trial, where the prosecution presents its case outline. In simple English, when a case has been committed to the Court of Session and the accused appears before that court, the public prosecutor must open the case. This means the prosecutor explains what the charges are and what evidence, documents, witnesses, materials the prosecution plans to use to prove the accused's guilt. This is not evidence recording yet. It is only a summary or introduction of the prosecution's case. Key points of Section 233 applies only in trials before a court of session. The public prosecutor speaks first. The court gets an overall picture of the case, helps the judge decide whether there is sufficient ground to proceed further. Why this section is important? It ensures the trial begins in an orderly and transparent manner. It protects the accused's right to know the nature of allegations. It helps the judge decide the next step, such as framing of charges or discharge of the accused, covered in the next section. In short, Section 233 marks the formal start of a sessions trial by requiring the prosecution to clearly explain its case and proposed evidence to the court. Section 234 Discharge of the accused. What this section is about. Section 234 explains when and how an accused person can be discharged, released from the case by the court of session before the trial actually begins. In simple English, after hearing the prosecution's opening statement under Section 233 and after examining the case record and the documents submitted, if the sessions judge believes that there is no sufficient ground to proceed against the accused, then the court shall discharge the accused. However, the judge must record reasons in writing for discharging the accused. Key points of Section 234 applies only to sessions court trials. Comes after the prosecution opens the case. The judge evaluates whether the case is groundless. Discharge happens before framing of charges. Written reasons are mandatory. Why this section is important. Protects individuals from unnecessary criminal trials. Prevents wastage of court time. Ensures only cases with prima facie evidence go forward. Upholds the principle of fair justice. In short, if the Sessions Court finds that the evidence on record does not justify a trial, it can discharge the accused under Section 234. Section 234 Framing of Charge. What this section is about. Section 235 explains what the Court of Session must do when it finds sufficient grounds to proceed against the accused after considering the case materials. If the case is not groundless, i.e., discharge under Section 234 is refused, the court moves to frame charges. In simple English, after hearing the prosecution and examining the records, if the sessions judge believes that the accused has committed an offense, then the judge frames a formal charge against the accused. The charge must be written clearly, read and explained to the accused. The accused is then asked whether he pleads guilty or Claims to be tried. Key points of Section 235. Applies only to Sessions Court trials. Comes after rejection of discharge. Charge must be specific and clear. Accused must understand the charge. Accused gets a chance to plead guilty or not guilty. Why this section is important? It formally defines what offense the accused must defend. Ensures the accused is fully informed. Prevents surprise or unfair prosecution. Marks the real beginning of the trial. In short, Section 235 provides that when sufficient grounds exist, the Sessions Court shall frame charges, explain them to the accused, and ask for the accused's plea. Here is a clear and exam-oriented explanation in English of Section 236 of the Bharatiya Nagarik Suraksha Sanhita 2023. Section 236 Conviction on Plea of Guilty. What this section is about. Section 236 explains what the Court of Session can do if the accused pleads guilty after the charge has been framed under Section 235. In simple English, once the charge is framed and explained, if the accused pleads guilty, the Sessions judge records the plea and may convict the accused based on that plea. However, conviction is not automatic. The judge has the discretion to decide whether it is proper to convict solely on the guilty plea. Key points of Section 236. Applies to Sessions Court trials. Comes after framing of charge. Accused must plead guilty voluntarily. Judge must record the plea. Court has discretion to convict or not. Why this section is important. Saves time of the court when guilt is admitted. Prevents unnecessary trial proceedings. Ensures that conviction is made only after judicial satisfaction. Protects against forced or uninformed guilty pleas. In short, under Section 236, if the accused pleads guilty, the Sessions Court may record the plea and convict the accused at its discretion. Section 237. Fixing date for examination of prosecution witnesses. What this section is about. Section 237 explains what the Court of Session must do when the accused does not plead guilty after the charge is framed. This section marks the beginning of the evidence stage of the trial. In simple English, if the accused pleads not guilty or refuses to plead or claims to be tried, then the Sessions Court must fix a date for examining prosecution witnesses and issue summons or orders to ensure attendance of prosecution witnesses and production of documents or other evidence. Key points of Section 237. Applies to Sessions Court trials. Comes after framing of charge. Used when the accused does not plead guilty. Court actively ensures witnesses are present. Leads to recording of prosecution evidence. Why this section is important. Formally starts the trial on evidence. Ensures the prosecution gets a fair opportunity to prove its case. Prevents unnecessary delays by fixing dates in advance. Maintains order and efficiency in sessions trials. In short, When the accused does not plead guilty, Section 237 requires the Sessions Court to fix a date and take steps to examine prosecution witnesses. Section 238 Evidence for the prosecution. What this section is about. Section 238 explains how the prosecution presents its evidence in a Sessions Court trial after the date for evidence has been fixed under Section 237. In simple English, on the fixed date or dates, the prosecution produces its witnesses before the court. The court examines the witnesses, examination in chief, allows cross-examination by the defense, and may allow re-examination if needed. The prosecution may also produce documents, material objects, and other evidence. The sessions judge may permit adjournments, but only for valid reasons and in the interest of justice. Key points of Section 238 applies to Sessions Court trials. Follow Section 237, fixing date for witnesses. Prosecution must prove the case through evidence. Defense has the right to cross-examine witnesses. Evidence is recorded under the supervision of the judge. Why this section is important? It is the core stage of the trial. Determines whether the prosecution can prove guilt beyond reasonable doubt. Protects the accused's right to a fair trial and cross-examination. Helps the court assess the credibility of witnesses and evidence. In short, Section 238 provides that the prosecution shall present its witnesses and evidence before the Sessions Court, and the defense has the right to cross-examine them. Section 239 Acquittal after prosecution evidence. What this section is about. Section 239 explains what the Court of Session must do after the prosecution has finished presenting its evidence. It deals with a situation where, even after all prosecution evidence, there is no proof that the accused committed the offense. In simple English, after the prosecution closes its evidence, if the sessions judge finds that no evidence has been produced that connects the accused with the offense, or the evidence is so weak that no conviction is possible, the court shall record an order of acquittal. This means the accused is found not guilty at this stage without calling for any defense evidence. Key points of Section 239 applies to Sessions Court trials. Comes after prosecution evidence is completed. Used when there is no incriminating evidence. Court must record reasons for acquittal. Accused is released without defense stage. Why this section is important. Prevents unnecessary continuation of trials. Protects accused persons from being forced to defend baseless cases. Saves judicial time. Upholds the principle that prosecution must first prove its case. In short, if, after prosecution evidence, the court finds no evidence against the accused, it must acquit the accused under Section 239. Section 240 Examination of the accused. What this section is about. Section 240 explains how and why the Court of Session examines the accused after the prosecution evidence is completed and the accused is not acquitted under Section 239. In simple English, If the case continues after prosecution evidence, the court questions the accused personally. The purpose is to explain the evidence appearing against him and give the accused a chance to explain the circumstances. This examination is done without oath, meant only for clarification, not for cross-examination. The answers given by the accused are not sworn testimony, but may be taken into consideration by the court. Key points of Section 240 happens after prosecution evidence. Accused is examined personally by the judge. No oath is administered. Accused is not punished for false answers. Ensures accused gets a fair opportunity to explain. Why this section is important. Upholds principles of natural justice. Ensures the accused understands the case against him. Prevents conviction without hearing the accused's explanation. Helps the judge reach a fair and balanced decision. In short, Section 240 requires the Sessions Court to question the accused personally so that he may explain any evidence appearing against him. Section 241 Evidence for the Defense. What this section is about. Section 241 explains how the accused can present his defense after prosecution evidence is completed and the accused has been examined by the court under Section 240. In simple English, if the accused is not acquitted and wishes to defend himself, the accused is allowed to produce defense witnesses and/or submit documents or other evidence in support of his defense. The court must issue summons or orders to ensure attendance of defense witnesses or production of documents unless the request is frivolous or meant to delay the trial. Key points of Section 241 applies to Sessions Court trials. Comes after examination of the accused. Defense evidence is optional. Accused may remain silent. Court must assist in calling defense witnesses. Requests can be refused only for valid reasons. Why this section is important. Protects the right to a fair defense. Ensures equality between prosecution and defense. Allows the accused to rebut prosecution evidence. Prevents misuse of defense stage to delay justice. In short, Section 241 gives the accused the right to present defense evidence and obliges the court to help in summoning defense witnesses unless the request is unreasonable. Section 242 Arguments of the prosecution and defense. What this section is about. Section 242 explains the final stage before judgment in a sessions trial, where both sides present their arguments based on the evidence on record. In simple English, after prosecution evidence is completed, the accused is examined and defense evidence, if any, is recorded. The court shall hear arguments from the public prosecutor and then hear arguments from the defense, accused or his lawyer. Both sides analyze the evidence, point out strengths and weaknesses, and try to persuade the court in their favor. Key points of Section 242 applies to Sessions Court trials. Comes after defense evidence. Both sides get full opportunity to argue. Arguments are based only on recorded evidence. Leads directly to judgment. Why this section is important. Ensures fair hearing to both parties. Helps the judge understand the case clearly. Allows legal interpretation of facts and law. Forms the basis for a reasoned judgment. In short, Section 242 provides that after evidence is completed, the Sessions Court shall hear final arguments from the prosecution and the defense. Section 243, Judgment of Acquittal or Conviction. What this section is about. Section 243 explains how the Sessions Court must decide the case after hearing final arguments. It deals with the pronouncement of judgment, either acquittal or conviction. In simple English, after hearing the arguments of both sides, Section 242. The Sessions Judge considers the entire evidence and delivers a judgment. The judgment may be acquittal if the prosecution fails to prove the case beyond reasonable doubt, or conviction if the accused is proved guilty. If the accused is convicted, the judge will hear the accused on the question of punishment. This leads to the next section. Key points of Section 243 applies to Sessions Court trials. Comes after final arguments. Judgment must be based on evidence and law. Court may either acquit or convict. Reasons must be clearly recorded. Why this section is important. Marks the final decision of the trial. Ensures judgments are reasoned and lawful. Protects the accused from arbitrary conviction. Upholds public confidence in the criminal justice system. In short, Section 243 requires the Sessions Court to deliver a reasoned judgment of acquittal or conviction after considering all evidence and arguments. Section 244, Hearing the accused on the question of sentence. What this section is about. Section 244 explains what the Sessions Court must do after convicting an accused person. It focuses on giving the accused a chance to be heard before punishment is decided. In simple English, if the court convicts the accused under Section 243, the judge must hear the accused on the question of sentence. The accused may explain personal circumstances, age, health, family, request leniency, or present reasons for a less severe punishment. Only after hearing the accused, the court decides and pronounces the sentence according to law. Key points of Section 244 applies only after conviction. Hearing on sentence is mandatory. Accused gets a chance to mitigate punishment. Judge must consider facts, circumstances, and law. Ensures sentence is fair and proportionate. Why this section is important. Upholds natural justice, hear the other side. Prevents arbitrary or harsh sentencing. Allows individualized punishment. strengthens fairness in criminal trials. In short, after convicting the accused, Section 244 requires the Sessions Court to hear the accused on the question of punishment before passing sentence. Section 245, Judgment in Trials before the Court of Session. What this section is about. Section 245 explains how a judgment of the Sessions Court must be written and what it must contain after the trial is completed. In simple English, when the Sessions Court delivers its judgment, the judgment must be written and pronounced in open court. It must clearly state the points for determination, issues the court considered, the decision on each point, and the reasons for those decisions. If the accused is convicted, the judgment must also specify the offense and the punishment awarded. If the accused is acquitted, the judgment must clearly say so. Key points of Section 245 applies to Sessions Court judgments. Judgment must be reasoned and detailed. Must be pronounced in open court. Conviction judgments must mention sentence. Ensures transparency and accountability. Why this section is important. Ensures judgments are not arbitrary. Helps higher courts during appeals or revisions. Gives clarity to accused, victims, and prosecution. Upholds rule of law and fair procedure. In short, Section 245 requires that a Sessions Court judgment be written, reasoned, and pronounced in open court, clearly stating the decision and reasons. Section 246, Previous Conviction. What this section is about. Section 246 explains how a court should deal with a previous conviction of the accused when it is relevant for enhancing punishment. In simple English, if the prosecution wants the court to consider a previous conviction of the accused in order to seek a higher or enhanced punishment, then the fact of the previous conviction must be clearly stated in the charge. The accused must be informed about it and given a chance to deny or explain the previous conviction. After the court records a conviction in the present case, the judge may take evidence regarding the previous conviction and decide whether the previous conviction is proved. Only after proof, the court may impose enhanced punishment as permitted by law. Key points of Section 246. Applies when previous conviction affects punishment. Previous conviction must be specifically mentioned. Accused must get a fair opportunity to contest it. Proof of previous conviction is required. Prevents surprise or unfair sentencing. Why this section is important. Protects the accused from unexpected harsher punishment. Ensures fair sentencing procedure. Maintains transparency in habitual offender cases. Balances justice and deterrence. In short, Section 246 provides that a previous conviction can be considered for enhanced punishment only if it is properly charged and proved, after giving the accused a fair opportunity to respond. Section 247, Procedure in cases instituted otherwise than on a police report. What this section is about. Section 247 explains how magistrate conducts a trial in cases that are not based on a police report. These are usually complaint cases filed directly by a private person. In simple English, when a case is started on a private complaint, not by police investigation, the magistrate hears the prosecution, the complainant, and the prosecution produces its witnesses and evidence. The magistrate records the examination of prosecution witnesses and allows the accused to cross-examine those witnesses. This stage is similar to prosecution evidence in a sessions trial but is conducted by a magistrate. Key points of Section 247 applies to complaint cases. No police report involved. Prosecution evidence is recorded first. Accused has the right to cross-examination. Trial proceeds under magistrate's supervision. Why this section is important. Lays down a fair procedure for private complaint cases. Ensures accused gets a chance to challenge prosecution evidence. Prevents misuse of complaint cases. Upholds natural justice principles. In short, Section 247 provides that in complaint cases, the magistrate shall hear the prosecution and record its evidence before proceeding further. Section 248 Acquittal of the accused in complaint cases. What this section is about. Section 248 explains when a magistrate must acquit the accused in cases instituted otherwise than on a police report, i.e., private complaint cases, after the prosecution evidence is completed. In simple English, after the complainant, prosecution, has produced all its evidence. If the magistrate finds that no case is made out against the accused, or the evidence is insufficient to justify conviction, the magistrate shall record an order of acquittal. This acquittal happens before calling upon the accused to enter his defense. Key points of Section 248 applies to complaint cases. Comes after prosecution evidence. Used when prosecution fails to prove a prima facie case. No defense evidence is required at this stage. Magistrate must record reasons for acquittal. Why this section is important. Protects accused persons from baseless private complaints. Prevents unnecessary continuation of trials. Saves judicial time. Ensures that only cases with substance proceed further. In short, if, after prosecution evidence in a complaint case, no case is made out against the accused, the magistrate must acquit the accused under Section 248. Section 249 Examination of the accused, complaint cases. What this section is about. Section 249 explains when and how the magistrate examines the accused in cases instituted otherwise than on a police report, private complaint cases, after prosecution evidence is completed and the accused is not acquitted under Section 248. In simple English, if the case continues after prosecution evidence, the magistrate questions the accused personally. The purpose is to put before the accused the circumstances and evidence appearing against him and give the accused a chance to explain those facts. This examination is done without administering an oath, is not cross-examination, and is meant only to ensure fairness. The answers are not sworn testimony, but may be considered by the court while deciding the case. Key points of Section 249 applies to complaint cases. Comes after prosecution evidence. Mandatory if the case proceeds further. No oath is administered. Ensures accused gets a fair opportunity to explain. Why this section is important. Upholds natural justice. Prevents conviction without hearing the accused. Helps the magistrate understand the accused's version. Strengthens fairness in magistrate trials. In short, Section 249 requires the magistrate to personally examine the accused in a complaint case so that he may explain the evidence appearing against him. Section 250 Evidence for the defense, complaint cases. What this section is about. Section 250 explains how the accused can present defense evidence in cases instituted otherwise than on a police report, private complaint cases, after prosecution evidence is completed and the accused has been examined under Section 249. In simple English, if the accused is not acquitted and wants to defend himself, the accused may produce defense witnesses and/or submit documents or other evidence. The magistrate shall issue summons or orders to call defense witnesses or documents, unless the request appears to be frivolous or intended to delay the trial. Defense evidence is optional. The accused may also choose to remain silent. Key points of Section 250 applies to complaint, private cases. Comes after examination of the accused. Defense evidence is a right, not a compulsion. Court must assist in summoning defense witnesses. Requests can be refused only for valid reasons. Why this section is important. Ensures the right to a fair defense. Maintains equality between prosecution and defense. Prevents misuse of defense stage to delay justice. Strengthens credibility of magistrate trials. In short, Section 250 gives the accused the right to present defense evidence in complaint cases, and the magistrate must help in summoning such evidence unless the request is unreasonable. Section 251 Arguments and Judgment in Complaint Cases. What this section is about. Section 251 explains the final stage of a magistrate trial in complaint cases, where the court hears arguments and then decides the case. In simple English, after prosecution evidence is completed, the accused is examined, and defense evidence, if any, is recorded, the magistrate shall hear arguments from the complainant prosecution and the accused or his advocate. Consider the entire evidence and arguments and then pronounce judgment. The judgment may result in acquittal if the offense is not proved, or conviction if the offence is proved beyond reasonable doubt. Key points of Section 251 applies to complaint, private cases. Comes after defense evidence. Both sides get a full opportunity to argue. Magistrate must give a reasoned judgment. Judgment may be conviction or acquittal. Why this section is important? Ensures fair hearing to both sides. Helps the magistrate reach a just decision. Maintains transparency and accountability. Completes the trial process in complaint cases. In short, Section 251 provides that after hearing final arguments in a complaint case, the magistrate shall deliver a reasoned judgment of conviction or acquittal. Section 252 Conviction on plea of guilty, magistrate trials. What this section is about. Section 252 explains what a magistrate may do if the accused pleads guilty in cases tried by magistrate, especially in complaint cases. In simple English, when the accused appears before the magistrate, the charge is stated and explained to the accused. If the accused voluntarily pleads guilty, the magistrate records the plea and may convict the accused on the basis of that plea. Conviction is not automatic. The magistrate must be satisfied that the plea is voluntary and the accused understands the nature of the offence. Key points of Section 252 applies to magistrate trials. Plea of guilty must be clear and voluntary. Magistrate must record the plea. Court has discretion to convict. No full trial is needed if conviction is recorded. Why this section is important? Saves time of the court. Avoids unnecessary trial when guilt is admitted. Protects accused from forced or uninformed pleas. Ensures speedy justice. In short, under Section 252, if an accused pleads guilty before a magistrate, the magistrate may record the plea and convict the accused, provided the plea is voluntary and informed. Section 253. Procedure when accused does not plead guilty, magistrate trials. What this section is about. Section 253 explains what a magistrate must do when the accused does not plead guilty in a case tried by magistrate. It ensures that the trial proceeds fairly and systematically when guilt is denied. In simple English, when the charge is explained to the accused and the accused pleads not guilty, or the accused refuses to plead, or the accused claims to be tried, then the magistrate shall fix a date for examination of prosecution witnesses and proceed to hear the prosecution evidence to prove the charge. This begins the evidence stage of a magistrate trial. Key points of Section 253 applies to magistrate trials. Used when the accused denies guilt. Court fixes dates for prosecution evidence. Leads to recording of witness testimony. Ensures structured continuation of the trial. Why this section is important. Protects the accused's right to contest the charge. Prevents conviction without evidence. ensures the prosecution proves its case, upholds fair trial principles. In short, if the accused does not plead guilty, Section 253 requires the magistrate to proceed with the trial by fixing dates for prosecution evidence. Section 254 Evidence for the prosecution, magistrate trials. What this section is about. Section 254 explains how the prosecution presents its evidence in cases tried by magistrate when the accused does not plead guilty after Section 253. In simple English, when the trial proceeds, the prosecution produces its witnesses before the magistrate. The magistrate examines the prosecution witnesses, allows the accused to cross-examine them, and may permit re-examination if required. The prosecution may also produce documents and material evidence to support its case. The magistrate may grant adjournments, but only for valid reasons to avoid unnecessary delay. Key points of Section 261 applies to magistrate trials. Follow Section 253 when accused pleads not guilty. Prosecution must prove the case through evidence. Accused has the right to cross-examine witnesses. Evidence is recorded under court supervision. Why this section is important. Forms the foundation of the prosecution case. Ensures fair opportunity to challenge prosecution evidence. Helps the magistrate assess credibility and reliability. Upholds the principle that guilt must be proved by evidence. In short, Section 254 provides that in magistrate trials, the prosecution shall produce its witnesses and evidence, and the accused has the right to cross-examine them. Section 255 Acquittal or conviction in magistrate trials. What this section is about. Section 255 explains what the magistrate must do after the prosecution evidence is completed in a case tried by magistrate. It deals with 3 possible outcomes at this stage. In simple English, after the prosecution evidence under Section 254. Acquittal. If the magistrate finds that no case is proved against the accused shall be acquitted. Though conviction. If the magistrate finds the accused guilty, the magistrate may convict the accused before passing sentence. The magistrate must hear the accused on the question of punishment. Then proceed further, if needed. If the magistrate thinks further steps are required, like defense examination, the trial continues as per law. Key points of Section 255 applies to magistrate trials. Comes after prosecution evidence. Magistrate can acquit or convict. Hearing on sentence is mandatory before punishment. Ensures a reasoned decision. Why this section is important. Prevents conviction without sufficient evidence. Ensures fair hearing on punishment. Saves court time by allowing early acquittal. Upholds principles of natural justice. In short, after prosecution evidence, Section 255 empowers the magistrate to acquit the accused if no case is proved, or convict the accused after hearing him on the question of sentence. Section 256, non-appearance or death of the complainant. What this section is about. Section 256 explains what a magistrate should do in a complaint case when the complainant does not appear before the court or when the complainant has died. In simple English, in a case instituted on a private complaint. One key cap when the complainant does not appear. If, on the date fixed for hearing, the complainant is absent, the magistrate may acquit the accused, unless the magistrate thinks it proper to adjourn the hearing, or the complainant is represented by a lawyer or authorized person, or the magistrate decides that the complainant's personal presence is not necessary. To key cap when the complainant has died. If the complainant has died, the magistrate may allow the legal representative to continue the case or proceed as the interests of justice require, including acquitting the accused if continuation is not justified. Key points of Section 256. Applies only to complaint, private cases. Protects accused from harassment due to complainant's absence. Magistrate has discretion to adjourn or acquit. Legal representative may continue the case. Ensures balance between justice and fairness. Why this section is important. Prevents misuse of criminal law by non-serious complainants. Saves court time. Protects accused from unnecessary delay. Allows genuine cases to continue even after complainant's death. In short, if the complainant is absent or has died in a complaint case, Section 256 empowers the magistrate to acquit the accused or continue the case depending on what justice requires. Section 257, withdrawal of complaint. What this section is about. Section 257 explains when and how a complainant can withdraw a complaint in a case instituted on a private complaint before a magistrate. In simple English, in a complaint case, the complainant may withdraw the complaint at any time before a final order is passed and with the permission of the magistrate. If the magistrate allows the withdrawal, the accused shall be acquitted. The magistrate must ensure that the withdrawal is voluntary and it is not against the interests of justice. Key points of Section 257. Applies only to complaint, private cases. Withdrawal requires court permission. Can be done before final judgment. On withdrawal, accused is acquitted. Magistrate must exercise judicial discretion. Why this section is important. Prevents forced or collusive withdrawals. Protects accused from continued unnecessary prosecution. Allows settlement in minor or personal disputes. Ensures withdrawal does not defeat justice. In short, Section 257 allows a complainant to withdraw a complaint with the magistrate's permission, and upon such withdrawal, the accused is acquitted. Section 258, power of magistrate to stop proceedings in certain cases. What this section is about. Section 258 gives a magistrate the power to stop criminal proceedings in summons cases that are instituted otherwise than on a complaint generally cases based on police reports. In simple English, in a summons case, less serious offences. If the case is not a private complaint case, the magistrate may stop the proceedings at any stage without delivering a full judgment if continuing the case is not necessary or justified. Effect of stopping proceedings. If proceedings are stopped before any evidence is recorded, the accused is released, and this release has the effect of discharge. If proceedings are stopped after some evidence is recorded, the accused is released, and this release has the effect of acquittal. Key points of Section 258 applies only to summons cases. Case must be instituted otherwise than on a complaint. Magistrate can act at any stage. Release may amount to discharge or acquittal. Power must be exercised judicially. Why this section is important? Prevents wastage of judicial time. Protects accused from unnecessary or trivial prosecutions. Allows courts to stop cases where continuation serves no useful purpose. Balances efficiency and fairness in criminal trials. In short, Section 258 empowers a magistrate to stop proceedings in certain summons cases and release the accused, which may amount to discharge or acquittal depending on the stage of the case. Section 259 Conversion of summons case into warrant case. What this section is about? Section 259 explains when a magistrate can change the procedure of a case from a summons case, less serious, to a warrant case, more serious. In simple English, during the trial of a summons case, if the magistrate finds that the nature of the offence or the facts and circumstances of the case make it more appropriate to follow the warrant case procedure, then the magistrate may convert the summons case into a warrant case. After conversion, the magistrate will rehear the case and proceed according to the procedure prescribed for warrant cases. Key points of Section 259 applies only to summons cases. Conversion depends on seriousness revealed during trial. Magistrate has judicial discretion. Case is then tried as a warrant case. Ensures correct procedure for serious matters. Why this section is important? Prevents misuse of simplified summons procedure in serious cases. Ensures greater procedural safeguards for accused and prosecution. Allows flexibility when the true gravity of offence appears later. Helps achieve substantive justice. In short, Section 259 empowers a magistrate to convert a summons case into a warrant case if the circumstances of the case require a more serious trial procedure. Section 260 Summary Trials. What this section is about? Section 260 explains which cases can be tried summarily, i.e., by a short and speedy procedure, and which magistrates are empowered to conduct such trials. In simple English, certain less serious offences can be tried through a summary procedure to save time and ensure speedy justice. Who can conduct summary trials? The following magistrates may try cases summarily. Chief Judicial Magistrate, judicial magistrate of the first class, and metropolitan magistrate, if specially empowered by the High Court. Cases that may be tried summarily. Summary trial may be conducted for offences such as minor theft, receiving stolen property of small value, insult, criminal intimidation, minor. Other offences punishable with imprisonment up to 2 years as prescribed. Important limit. Even in summary trials, no sentence of imprisonment exceeding 3 months can be passed. Key points of Section 260. Applies to minor offences. Only empowered magistrates can use this procedure. Trial is simplified and fast. Evidence and judgments are briefly recorded. Maximum punishment is restricted. Why this section is important? Reduces burden on courts. Ensures speedy justice. Prevents unnecessary lengthy trials for small offences. Balances efficiency with fairness. In short, Section 260 allows empowered magistrates to try minor offences through a summary procedure, ensuring quick disposal with limited punishment. Section 261. Summary trial of certain offences. What this section is about. Section 261 specifies which types of offences may be tried summarily by a magistrate, focusing on minor offences with lesser punishment. In simple English, under this section, summary trials may be conducted for offences that are punishable with fine only or punishable with imprisonment for a term not exceeding 6 months, with or without fine. These cases can be tried using a simplified and speedy procedure instead of a full-length trial. Key points of Section 261. Applies to minor offences. Offences must carry low punishment. Trial procedure is summary and quick. Less time-consuming for courts and parties. Still ensures basic fairness and justice. Why this section is important? Helps in fast disposal of petty cases. Reduces case backlog in magistrate courts. Prevents unnecessary delay and expense. Ensures proportionate procedure for minor crimes. In short, Section 261 allows magistrates to summarily try offences punishable with fine only or imprisonment up to 6 months, ensuring speedy justice for minor cases. Section 262 Procedure for Summary Trials. What this section is about. Section 262 explains how summary trials are to be conducted. It lays down the procedure and limits applicable when a magistrate tries a case summarily. In simple English, in a summary trial, the procedure of summons cases is followed, but in a simplified form. The magistrate does not record full detailed evidence. Only the substance of the evidence and proceedings is recorded. Important restriction. No sentence of imprisonment exceeding 3 months can be passed in a summary trial, even if the law provides a higher punishment for that offence. Key points of Section 262. Applies only to summary trials. Procedure is based on summons case rules. Evidence is recorded briefly. Detailed judgment is not required. Maximum imprisonment allowed is 3 months. Why this section is important? Ensures speedy disposal of minor cases. Reduces procedural complexity. Protects accused from harsh punishment in summary proceedings. Balances efficiency with fairness. In short, Section 262 provides that summary trials follow summons case procedure in a simplified manner with brief recording of evidence and a maximum punishment of 3 months imprisonment. Section 263 Record in summary trials. What this section is about. Section 263 explains what record a magistrate must maintain when a case is tried by the summary procedure. Because summary trials are meant to be quick, the law requires only a brief record, not a detailed one. In simple English, in every summary trial, the magistrate must record the following particulars: serial number of the case, date of commission of the offence, date of report or complaint, name of the complainant, if any, name, parentage, and residence of the accused, offence complained of, and offence proved, if different, plea of the accused and his examination, if any, finding of the magistrate, sentence or final order, and date on which proceedings ended. These details ensure that, even in a fast-track process, basic transparency and accountability are maintained. Key points of Section 263. Applies only to summary trials. Requires brief but essential record. No detailed judgment is necessary. Helps in review, appeal, or revision. Ensures legality of summary procedure. Why this section is important? Prevents arbitrariness in summary trials. Maintains an official record despite simplified procedure. Protects rights of both accused and complainant. Assists higher courts if the case is later examined. In short, Section 263 mandates that the magistrate must maintain a concise record of essential details in every summary trial. Section 264 Judgment in cases tried summarily. What this section is about. Section 264 explains how a magistrate must write the judgment in cases that are tried by the summary procedure. Because summary trials are meant to be quick, the judgment is short and concise. In simple English, in a summary trial, when the magistrate delivers judgment, the judgment must be written and contain only a brief statement of the reasons for the decision. A detailed judgment is not required like in regular trials. However, the judgment must still clearly show why the accused is convicted or acquitted and that the magistrate has applied judicial mind. Key points of Section 264. Applies only to summary trials. Judgment must be written. Only brief reasons are required. No lengthy discussion of evidence needed. Ensures speed with minimum formality. Why this section is important? Supports the objective of speedy justice. Reduces workload of courts. still ensures transparency and fairness, allows higher courts to understand the basis of the decision if reviewed. In short, Section 264 provides that in summary trials, the magistrate shall record a brief written judgment stating the reasons for conviction or acquittal. Section 265 Language of Records and Judgments. What this section is about. Section 265 explains in which language criminal court records and judgments must be written. Its purpose is to ensure uniformity, clarity, and official correctness in court proceedings. In simple English, under this section, all records and judgments of criminal courts shall be written in the language of the court or any other language directed by the state government. If evidence or statements are recorded in a different language, the court may provide a translation when necessary. This ensures that judges, lawyers, and higher courts can clearly understand the record and proceedings remain legally valid. Key points of Section 265 applies to all criminal courts, covers records, evidence, and judgments. Language is as prescribed by state government. Translation may be provided when required. Ensures clarity and uniform court practice. Why this section is important. Maintains consistency in judicial records. Helps appeals, revisions, and reviews. Avoids confusion caused by multiple languages. Strengthens administration of justice. In short, Section 265 provides that criminal court records and judgments shall be written in the language of the court or as directed by the state government. Section 266 Sentence of death to be submitted for confirmation. What this section is about. Section 266 explains what happens when a sessions court passes a sentence of death. It lays down the rule that a death sentence cannot be carried out unless it is confirmed by the High Court. In simple English, if a sessions court convicts an accused and awards the death penalty, the court must submit the proceedings to the High Court. The death sentence cannot be executed immediately. Execution is allowed only after the High Court confirms the sentence. Until confirmation, the accused is usually kept in custody. Key points of Section 266. Applies only when death sentence is awarded. Sessions Court cannot execute the sentence on its own. High Court confirmation is mandatory. Provides an additional layer of judicial scrutiny. Protects against wrongful execution. Why this section is important. Safeguards the right to life. Ensures careful review in the gravest punishment. Prevents irreversible judicial errors. Reflects the principle that death penalty requires highest caution. In short, under Section 266, a death sentence passed by a sessions court must be sent to the High Court and cannot be executed unless the High Court confirms it. Section 267, Procedure when death sentence is submitted for confirmation. What this section is about. Section 267 explains the procedure followed by the High Court after a sessions court submits a death sentence for confirmation under Section 266. In simple English, when a death sentence reaches the High Court for confirmation. The High Court shall examine the entire record of the case and hear the accused or his lawyer and the public prosecutor. The High Court may also order further inquiry or take additional evidence itself or direct it to be taken by a lower court. This ensures that the case is reviewed thoroughly and independently. Key points of Section 267 applies after a death sentence is passed. High Court must re-examine the whole case. Accused has the right to be heard. High Court may take additional evidence. Ensures careful judicial scrutiny. Why this section is important? Provides a second, higher-level review of the most serious punishment. Protects against miscarriage of justice. Upholds the constitutional right to life. Ensures fairness and due process. In short, Section 267 requires the High Court to thoroughly examine the case, hear both sides, and if necessary take further evidence before deciding whether to confirm a death sentence. Section 268 Powers of the High Court on confirmation of death sentence. What this section is about. Section 268 explains what options the High Court has when a death sentence is sent to it for confirmation under Sections 266 and 267. In simple English, after examining the case record and hearing both sides, the High Court may confirm the death sentence or pass any other lawful sentence, for example, life imprisonment, or acquit the accused, or order a new trial on the same or amended charge, or convict the accused for a different offense proved by the evidence, and pass an appropriate sentence. The High Court is not bound by the Sessions Court's decision and may take an independent view. Key points of Section 268 applies only in death sentence confirmation cases. High Court has wide discretionary powers. Can confirm, reduce, alter, or set aside the sentence. Can order retrial or acquittal. Decision must be reasoned and judicial. Why this section is important. Ensures maximum judicial safeguards in capital punishment cases. Prevents irreversible errors in sentencing. Reinforces the principle that death penalty is an exception. Upholds fairness, justice, and constitutional values. In short, Section 268 empowers the High Court to confirm, alter, or set aside a death sentence, order a retrial, or pass any lawful sentence after full judicial review. Section 269 Confirmation or new sentence to be signed by two judges. What this section is about. Section 269 lays down an important safeguard in death sentence cases. It requires that certain decisions of the High Court must be made by more than one judge. In simple English, when a death sentence case comes before the High Court, any order confirming the death sentence or any order passing a new sentence or any order acquitting the accused must be made and signed by at least two judges of the High Court. A single judge cannot finally decide such matters. Key points of Section 269. Applies only to death sentence confirmation proceedings. Decision must be by minimum to High Court judges. Applies to confirmation, alteration, or acquittal. Ensures collective judicial responsibility. Strengthens safeguards in capital punishment cases. Why this section is important? Prevents individual error in the gravest cases. Ensures greater deliberation and caution. Protects the right to life. Increases public confidence in criminal justice. In short, Section 269 mandates that any High Court decision confirming, altering, or setting aside a death sentence must be signed by at least 2 judges. Section 270 Procedure in case of difference of opinion between High Court judges. What this section is about. Section 270 explains what happens if the High Court judges do not agree with each other while deciding a death sentence confirmation case. In simple English, if a death sentence case is heard by 2 or more judges of the High Court and they differ in opinion on the decision, for example, confirmation, acquittal, or alteration of sentence, then the case shall be decided according to the opinion of the majority. If there is no majority, when the judges are equally divided in opinion, the case is referred to another judge or judges of the High Court. That judge hears the case and gives an opinion. The final decision follows the majority view after this reference. Key points of Section 270. Applies only to death sentence confirmation cases. Used when judges disagree. Decision is by majority opinion. Additional judge may be consulted. Ensures final and authoritative judgment. Why this section is important. Prevents deadlock in serious criminal cases. Ensures decisions are collective and reasoned. Adds an extra layer of judicial caution. Protects the accused in capital punishment matters. In short, Section 270 provides that if High Court judges differ in opinion in a death sentence case, the decision shall be made according to the majority view, with reference to another judge if required. Section 271 Power to confirm sentence or annul conviction. What this section is about. Section 271 explains the final powers of the High Court after completing the death sentence confirmation proceedings. It clarifies that the High Court's authority is not limited only to confirmation, but also extends to setting aside the conviction if required. In simple English, after examining the case under Sections 266 to 270, the High Court may confirm the sentence or annul, cancel the conviction and pass any appropriate order according to law. This means even at the confirmation stage, if the High Court finds that the conviction itself is illegal, unsafe, or unjust, it can set aside the conviction entirely. Key points of Section 271. Applies in death sentence confirmation cases. High Court has full authority over conviction and sentence. Can confirm, modify, or cancel the decision. Ensures justice is done even at the final review stage. prevents execution of an illegal or wrongful conviction. Why this section is important? Gives the High Court complete control over capital cases. Protects against irreversible judicial mistakes. Strengthens safeguards under Article 21, right to life. Ensures punishment is imposed only after full judicial satisfaction. In short, Section 271 empowers the High Court during death sentence confirmation proceedings to confirm the sentence or annul the conviction and pass any lawful order. Section 272 Execution of death sentence after confirmation. What this section is about? Section 272 explains when and how a death sentence can actually be carried out after it has been confirmed by the High Court. In simple English, once the High Court confirms the death sentence and all required legal procedures are completed, then the Sessions Court issues a warrant for execution of the death sentence. The sentence is executed in the manner prescribed by law and at the time and place specified in the warrant. Until confirmation, the death sentence cannot be executed. Key points of Section 272 applies only after High Court confirmation. Execution requires a formal warrant. Sessions Court acts after confirmation. Sentence executed as per legal procedure. Prevents premature or illegal execution. Why this section is important? Ensures strict legality in carrying out capital punishment. Protects the right to life until final confirmation. Prevents arbitrary or hurried execution. Maintains procedural discipline in the gravest punishment. In short, Section 272 provides that a death sentence may be executed only after High Court confirmation and issuance of a lawful warrant by the Sessions Court. Section 273 Postponement of execution of death sentence. What this section is about? Section 273 explains when and how the execution of a death sentence may be postponed, delayed, even after it has been confirmed. This section provides safeguards to ensure that no execution takes place while lawful remedies are still available. In simple English, the execution of a death sentence shall be postponed in situations such as when the accused has filed an appeal, revision, or petition before a higher court, or when a mercy petition to the President or Governor is pending, or when the court otherwise directs postponement in the interest of justice. During this period, the accused remains in custody and the death sentence cannot be carried out until the legal process is completed. Key points of Section 273 applies after confirmation of death sentence. Execution may be legally postponed. Protects the right to pursue appeals and mercy petitions. Prevents irreversible action during pending proceedings. Ensures compliance with constitutional safeguards. Why this section is important? Protects the right to life and due process. Ensures no execution occurs while legal remedies remain. Prevents irreversible miscarriage of justice. Reflects humanitarian and constitutional values. In short, Section 273 provides that execution of a death sentence shall be postponed while legal proceedings or mercy petitions are pending or when the court so directs. Section 274, imprisonment for life and execution of other sentences. What this section is about. Section 274 explains how sentences other than death are to be carried out, especially imprisonment for life after the court has passed the final order. In simple English, when a court sentences an accused to imprisonment for life, the sentence means imprisonment for the remainder of the convict's natural life, unless it is remitted, commuted, or reduced by competent authority like the government or president-governor. Other sentences, imprisonment or fine. Sentences of rigorous or simple imprisonment or fine or imprisonment in default of fine are executed according to law and prison rules after the judgment becomes final. Key points of Section 274. Clarifies meaning of life imprisonment. Life imprisonment, whole natural life. Execution follows final judgment, subject to remission or commutation by authority. Ensures clarity in execution of sentences. Why this section is important. Removes confusion about duration of life imprisonment. Prevents arbitrary release of life convicts. Ensures uniform execution of sentences. Balances punishment with executive powers of mercy. In short, Section 274 provides that life imprisonment means imprisonment for the convict's entire natural life, subject to lawful remission or commutation, and explains execution of other sentences. Section 275, execution of sentence of imprisonment. What this section is about. Section 275 explains how sentence of imprisonment is to be executed once it becomes final. It deals with the authority of the court to issue a warrant and the manner in which the convict is committed to prison. In simple English, when a person is sentenced to imprisonment by a criminal court, the court shall issue a warrant of commitment. This warrant authorizes the police or prison authorities to take the convicted person into custody and commit him to prison for the term of imprisonment awarded. If the convicted person is already in custody, the warrant is sent directly to the prison authority and the sentence begins as per law. Key points of Section 275. Applies to sentences of imprisonment. Court must issue a formal warrant. Warrant is authority for prison custody. Covers cases where convict is already in jail. Ensures lawful execution of sentence. Why this section is important. Prevents illegal detention. Ensures imprisonment is carried out only under court authority. Maintains proper judicial control over execution of sentences. Protects rights of the convicted person. In short, Section 275 provides that a sentence of imprisonment shall be executed by issuing a lawful warrant, under which the convicted person is committed to prison. Section 276 execution of sentence or fine. What this section is about. Section 276 explains how a sentence of fine imposed by a criminal court is to be recovered and enforced. In simple English, when a court sentences a person to pay a fine, the court may take one or more of the following steps to recover the fine. Issue a warrant to recover the fine by attachment and sale of movable property belonging to the convicted person, or issue a warrant to the collector to recover the fine as if it were arrears of land revenue. If the fine is not paid, the court may also order imprisonment in default of payment if such imprisonment is provided by law. Key points of Section 276 applies to sentences of fine. Court can recover fine through property attachment. Fine may be recovered via revenue authorities. Default imprisonment may be imposed if allowed. Ensures effective enforcement of monetary penalties. Why this section is important. Prevents convicts from escaping punishment by non-payment. Provides multiple legal methods to recover fines. Ensures fines are not merely symbolic. Strengthens credibility of court sentences. In short, Section 276 provides the procedure for recovery of fines, including attachment of property, recovery as land revenue, and imprisonment in default where permitted. Section 277 Levy of fine by attachment and sale of property. What this section is about. Section 277 explains how a criminal court can recover a fine by attaching and selling the property of a convicted person when the fine is not paid voluntarily. In simple English, if a person is sentenced to pay a fine and does not pay it, the court may issue a warrant for attachment, seizure, and sale of the convicted person's movable property. The money obtained from the sale is used to pay the fine, and any excess amount, after deducting expenses and fine, must be returned to the person. Key points of Section 277 applies when fine is unpaid. Recovery is through attachment and sale of movable property. Court issues a formal warrant. Sale proceeds are adjusted toward the fine. Balance, if any, is refunded. Why this section is important. Ensures effective enforcement of fines. Prevents convicts from avoiding punishment by non-payment. Provides a lawful and transparent recovery method. Protects the convicted person from excessive recovery. In short, Section 277 authorizes the court to recover an unpaid fine by attaching and selling the movable property of the convicted person and adjusting the sale proceeds towards the fine. Section 278 Imprisonment in default of payment of fine. What this section is about. Section 278 explains when and how a person can be sent to prison for not paying a fine imposed by a criminal court. This imprisonment is not a punishment for the offense itself, but a consequence of non-payment of fine. In simple English, if a person is sentenced to pay a fine and the fine is not paid, and the law allows imprisonment in default of fine, then the court may order the person to undergo imprisonment in default of payment. Important points. Default imprisonment can be simple or rigorous, depending on the law. Cannot exceed the maximum term prescribed. If the fine is paid later, the person must be released immediately, even if the default sentence has begun. Key points of Section 278 applies only when fine remains unpaid. Default imprisonment is separate from main sentence. Payment of fine at any time leads to release. Court must follow legal limits on duration. Ensures fines are taken seriously. Why this section is important. Prevents offenders from ignoring fines. Encourages compliance with court orders. Ensures fairness by allowing release on payment. Maintains balance between penalty and caution. In short, Section 278 provides that if a fine is not paid, the court may order imprisonment in default, but the convict must be released immediately upon payment of the fine. Section 279 Termination of imprisonment on payment of fine. What this section is about. Section 279 explains when imprisonment awarded in default of payment of fine must stop. It protects the convict by ensuring that payment of fine immediately ends default imprisonment. In simple English, if a person is undergoing imprisonment only because he failed to pay a fine, then at any time, if the fine is paid in full or the fine is lawfully recovered, for example, by attachment of property, the imprisonment must be terminated immediately and the person must be released at once. This applies even if the default imprisonment has already started. Key points of Section 279 applies only to imprisonment in default of fine. Payment or recovery of fine immediate release. Works at any stage of default imprisonment. Protects against unnecessary detention. Fine remains the primary punishment, not jail. Why this section is important. Ensures fairness and proportionality in punishment. Prevents jail from becoming a substitute for fine. Encourages payment rather than prolonged detention. Upholds human treatment of convicts. In short, Section 279 provides that imprisonment imposed in default of payment of fine shall immediately stop once the fine is paid or recovered. Section 280 Levy of fine even when imprisonment in default is imposed. What this section is about. Section 280 clarifies that imposing imprisonment in default of payment of fine does not cancel the liability to pay the fine. The fine can still be recovered by law, even if the accused has undergone or is undergoing default imprisonment. In simple English, if a person is sentenced to pay a fine and is also sentenced to imprisonment in default of payment of that fine, then the fine can still be recovered even if the person has already undergone the whole or part of the default imprisonment. This means default imprisonment is not a substitute for the fine. The court or authorities may still attach property or recover the fine through legal means. Key points of Section 280. Fine remains recoverable at all times. Default imprisonment does not wipe out the fine. Recovery can continue even after jail. Strengthens enforcement of monetary penalties. Prevents misuse of default imprisonment. Why this section is important? Prevents offenders from escaping financial punishment by going to jail. Ensures fines remain an effective deterrent. Maintains the distinction between fine and imprisonment. Supports discipline and authority of court orders. In short, Section 280 provides that a fine may be lawfully recovered even if the offender has undergone imprisonment in default of payment of the fine. Section 281 Execution of order for payment of costs or compensation. What this section is about? Section 281 explains how an order for payment of costs or compensation passed by a criminal court is to be enforced. Such orders are usually made to compensate the victim or to recover costs imposed by the court. In simple English, when a criminal court orders a person to pay costs or compensation, the order is executed in the same manner as a sentence of fine. This means the court may recover the amount by attachment and sale of property, or recover it as arrears of land revenue, or use any other lawful method applicable to fine recovery. If the person fails to pay, legal recovery proceedings may continue until the amount is realized. Key points of Section 281 applies to costs and compensation orders. Recovery follows procedure for fine. Ensures victims actually receive compensation. Strengthens enforcement of court orders. Prevents non-compliance with monetary directions. Why this section is important? Ensures victims are not left without relief. Makes compensation orders effective, not symbolic. Maintains authority of criminal courts. Promotes restorative justice. In short, Section 281 provides that orders for payment of costs or compensation shall be executed in the same manner as recovery of a fine. Section 282 Payment to be credited to government or paid to the entitled person. What this section is about? Section 282 explains whether money recovered by the court, fine, costs, or compensation should go whether to the government or to the person entitled to receive it. In simple English, when a criminal court recovers money, fines are generally credited to the government unless the law or the court directs otherwise. Compensation or costs are paid directly to the person entitled, such as the victim or the complainant or any other person named by the court. The court must ensure that the amount is properly accounted for and paid to the correct authority or person. Key points of Section 282 distinguishes between fine and compensation costs. Fine government. Compensation costs victim or entitled person. Ensures correct and lawful distribution. Prevents misuse or misdirection of recovered money. Why this section is important? ensures victims actually receive compensation, maintains financial transparency, clarifies the destination of court-recovered money, strengthens confidence in criminal justice administration. In short, Section 282 provides that fines recovered are credited to the government while compensation or costs are paid to the person entitled to receive them. Section 283 Warrant for levy of fine outside local jurisdiction. What this section is about. Section 283 explains how a fine can be recovered when the convicted person or his property is located outside the local jurisdiction of the court that passed the sentence. In simple English, if a criminal court issues a warrant to recover a fine and the property of the offender or the place where recovery is possible is outside the court's local jurisdiction, then the court may send the warrant to a magistrate or authority having jurisdiction over that area. The receiving authority executes the warrant as if it were issued by its own court and recovers the fine according to law. Key points of Section 283 applies when fine recovery is outside local limits. Original court can transfer the warrant. Local magistrate executes the warrant. Ensures effective recovery across jurisdictions. Prevents offenders from avoiding fines by moving property. Why this section is important. Ensures nationwide enforceability of court orders. Prevents convicts from escaping liability by shifting location. Promotes coordination between courts. Strengthens effectiveness of fine recovery system. In short, Section 283 allows a warrant for recovery of fine to be executed outside the local jurisdiction by sending it to the appropriate magistrate or authority. Section 284 Effect of imprisonment in default of fine on recovery proceedings. What this section is about. Section 284 explains whether recovery of a fine can continue when the offender has already been sentenced to imprisonment in default of payment of fine. In simple English, this section makes it clear that imprisonment in default of payment of fine does not automatically stop recovery of the fine. Even if the offender has started undergoing default imprisonment or has completed the entire default imprisonment, the fine can still be recovered unless the court specifically directs otherwise. However, if the court has ordered that fine shall not be recovered after default imprisonment, then recovery must stop. Key points of Section 284. Default imprisonment does not cancel the fine. Recovery can continue before, during, or after imprisonment. Court has discretion to stop recovery by express order. Strengthens enforcement of monetary penalties. Prevents offenders from avoiding fines by serving jail time. Why this section is important. Ensures fines remain an effective punishment. Prevents misuse of default imprisonment as a substitute. Maintains authority of court orders. Promotes financial accountability in criminal justice. In short, Section 284 provides that imprisonment in default of payment of fine does not bar recovery of the fine unless the court expressly orders otherwise. Section 285 Suspension of Execution of Sentence of Imprisonment. What this section is about. Section 285 explains when and how the execution of a sentence of imprisonment may be suspended after conviction. This usually happens when the convicted person files an appeal or is granted bail by the appellate court. In simple English, after a person is sentenced to imprisonment, if the court orders suspension of the sentence, then the execution of imprisonment is temporarily stopped. During suspension, the convicted person may be released on bail or allowed to remain out of prison until the appeal or proceeding is decided. Suspension does not cancel the conviction, it only pauses the punishment. Key points of Section 285 applies after conviction. Execution of imprisonment can be temporarily suspended, usually linked with appeal or bail. Conviction remains valid. Sentence resumes if suspension is lifted. Why this section is important. Protects the right to appeal. Prevents unnecessary imprisonment if conviction is later reversed. Ensures fairness and justice. Balances punishment with judicial review. In short, Section 285 provides that execution of a sentence of imprisonment may be suspended by the court, usually when an appeal is pending or bail is granted. Section 286 Suspension of Execution of Sentence or Fine. What this section is about. Section 286 explains when and how the execution, recovery, of a sentence of fine may be suspended after conviction, usually when the convicted person files an appeal. In simple English, after a court imposes a fine, if the convicted person appeals against the conviction or sentence, the appellate court may suspend the recovery of the fine and release the person from the obligation to pay the fine temporarily. The court may also require the convicted person to execute a bond or impose conditions to ensure payment if the appeal fails. Suspension means fine is not recovered for the time being, but the liability to pay the fine still exists. Key points of Section 286 applies to sentence of fine, usually exercised during appeal. Recovery of fine is temporarily stopped. Court may impose conditions or security. Fine becomes payable if appeal is dismissed. Why this section is important. Protects the appellant from irreversible recovery. Prevents hardship if conviction is later set aside. Balances rights of the accused and interest of justice. Ensures fines are recovered only after final decision. In short, Section 286 empowers the court to suspend the execution or recovery of a fine during the pendency of an appeal, subject to conditions. Section 287 Power of appropriate government to suspend or remit sentences. What this section is about. Section 287 gives the appropriate government, central or state, the power to suspend or remit a sentence, either wholly or in part, after a person has been convicted. This power is an executive power, separate from the courts. In simple English, under this section, the appropriate government may suspend the execution of a sentence or remit, reduce or cancel the whole or part of the sentence. This power can be exercised at any time with or without conditions and usually after considering factors like good conduct, age or health of the convict, humanitarian grounds, public interest. If conditions are imposed and the convict violates them, the suspension or remission may be cancelled and the remaining sentence may be enforced. Key points of Section 287. Power lies with the government, not the court. Applies after conviction. Can suspend or reduce any sentence. Conditions may be imposed. Violation of conditions leads to revival of sentence. Why this section is important? Allows humanitarian and reformative considerations. Enables executive review of punishment. Helps in rehabilitation of convicts. Balances justice with mercy. In short, Section 287 empowers the appropriate government to suspend or remit a sentence wholly or partly, with or without conditions, at any time after conviction. Section 288 Power of the appropriate government to commute sentences. What this section is about. Section 288 explains the power of the appropriate government to commute a sentence, that is, to substitute a lesser punishment for a harsher one after a person has been convicted. In simple English, under this section, the appropriate government, central or state, as the case may be, may commute the following sentences. Death sentence to life imprisonment. Life imprisonment to imprisonment for a lesser term. Rigorous imprisonment to simple imprisonment. Imprisonment to fine. This power can be exercised at any time after conviction and without the consent of the convicted person. Key points of Section 288. Power lies with the appropriate government. Applies after conviction. Sentence is reduced in severity, not cancelled. Consent of the convict is not required. Different from suspension or remission. Why this section is important. Allows flexibility and mercy in punishment. Helps in reformation and rehabilitation of convicts. Complements constitutional powers under Articles 72 and 161. Ensures punishment is just and proportionate. In short, Section 288 empowers the appropriate government to commute a sentence by substituting it with a lesser form of punishment without the consent of the convict. Section 289 Restrictions on powers of suspension, remission and commutation. What this section is about. Section 289 places important limits on the powers of the appropriate government to suspend, remit, or commute sentences in certain serious cases. It ensures that executive powers are exercised with caution and consultation. In simple English, in cases where a person is convicted of serious offences, especially those investigated by central agencies or involving union executive power, the state government cannot suspend, remit, or commute the sentence on its own. The state government must consult the central government before taking such action. This applies particularly when The offence relates to matters under the executive power of the Union, or the investigation was conducted by a central agency. Key points of Section 289 applies to serious or sensitive offences. Restricts unilateral action by state government. Consultation with central government is mandatory. Ensures coordinated decision-making. Prevents misuse of executive clemency powers. Why this section is important? Maintains federal balance between centre and states. Ensures national-level interests are protected. Prevents arbitrary reduction of sentences in serious crimes. Enhances transparency and accountability. In short, Section 289 restricts the power of the state government to suspend, remit, or commute sentences in certain serious cases unless it consults the central government. Section 290 power of the court to suspend or remit sentence after government order. What this section is about. Section 290 explains the role of the court after the government has exercised its power to suspend, remit, or commute a sentence under Sections 287, 289. It clarifies how the court must act to give effect to the government's decision. In simple English, when the appropriate government passes an order to suspend, remit, or commute a sentence, the court which passed the original sentence shall give effect to that government order and pass necessary directions, such as releasing the convict or modifying the sentence. The court does not re-examine the merits of the government's decision, it only implements it. Key points of Section 290 applies after a government order under Sections 287, 289. Court's role is ministerial implementation. Court must ensure proper execution of the government decision. No fresh trial or review by the court. Ensures coordination between executive and judiciary. Why this section is important. Prevents confusion between executive clemency and judicial powers. Ensures government orders are lawfully enforced. Maintains separation of powers while enabling cooperation. Protects convicts from delay in relief granted by the government. In short, Section 290 provides that when the government suspends, remits, or commutes a sentence, the court must give effect to that order by issuing appropriate directions. Section 291 effect of remission or commutation of sentence. What this section is about. Section 291 explains what legally happens to a sentence when it is remitted or commuted by the appropriate government under Sections 287 or 288. In simple English, when a sentence is remitted, remission means reducing or cancelling part of the punishment. The remaining part of the sentence, if any, continues to be enforceable. Commuted. Commutation means replacing the original sentence with a less severe sentence. After commutation, the new sentence takes effect and the original sentence is treated as replaced, not enforceable anymore. In both cases, the sentence is treated as lawfully modified and the convict is bound only by the revised punishment. Key points of Section 291 applies after government order of remission or commutation. Remission sentence is reduced. Commutation sentence is substituted. Original sentence changes by operation of law. Court and prison authorities must follow the modified sentence. Why this section is important. removes confusion about which sentence is enforceable, ensures smooth implementation of executive clemency, protects convicts from serving excess punishment, maintains legal certainty in sentence execution. In short, Section 291 provides that once a sentence is remitted or commuted by the government, the sentence takes effect in its modified form, and the original sentence stands altered accordingly. Section 292 Power to require offender to remain in custody in certain cases. What this section is about. Section 292 explains that even after remission or commutation of a sentence, the offender may still be required to remain in custody in specific situations. This section acts as a safeguard for public interest and legal continuity. In simple English, when the appropriate government remits, reduces, or commutes, substitutes a sentence, the offender does not automatically get released if he is liable to be detained for some other lawful reason, such as another pending sentence or detention under any other valid legal order. In such cases, the offender must continue to remain in custody until all lawful requirements are satisfied. Key points of Section 292 applies after remission or commutation. Release is not automatic. Custody may continue due to other legal grounds. Prevents premature or illegal release. Ensures lawful detention is respected. Why this section is important. Prevents misuse of remission or commutation. Ensures offenders do not escape custody due to technicalities. Maintains public safety and legal order. Coordinates multiple sentences or detention orders properly. In short, Section 292 provides that even after remission or commutation of a sentence, an offender may be required to remain in custody if he is otherwise legally liable to be detained. Section 293 Procedure when sentence is imprisonment for life. What this section is about. Section 293 explains the special procedure and legal effect when a person is sentenced to imprisonment for life. It clarifies how life imprisonment is to be treated for legal and administrative purposes. In simple English, when a person is sentenced to imprisonment for life, the sentence means imprisonment for the remainder of the person's natural life, unless it is remitted, commuted, or reduced by a competent authority, government constitutional authority. The prisoner cannot claim release automatically after 14 years or any fixed period. Can be released only if remission or commutation is granted according to law. Key points of Section 293 applies specifically to life imprisonment. Life imprisonment entire natural life. No automatic right to release. Release possible only through lawful remission or commutation. Clarifies confusion about duration of life sentence. Why this section is important. Prevents misunderstanding that life imprisonment means a fixed term. Ensures uniform application of life sentences. Protects public interest in serious offences. Aligns sentencing with constitutional and statutory principles. In short, Section 293 makes it clear that imprisonment for life means imprisonment for the convict's entire natural life, unless lawfully remitted or commuted by the competent authority. Section 294 Set-off of the period of detention undergone by the accused. What this section is about. Section 294 provides relief to an accused person by allowing the time already spent in custody during investigation, inquiry, or trial to be deducted from the final sentence of imprisonment. In simple English, if a person has been detained in jail during police investigation or court inquiry or trial and is later convicted and sentenced to imprisonment, then the period already spent in custody shall be set off against the term of imprisonment imposed. Example: if an accused was in jail for 1 year during trial and the court sentences him to 5 years imprisonment, he will have to serve only the remaining 4 years. Key points of Section 294 applies after conviction, covers pretrial and trial detention. Deduction is mandatory, not discretionary. Prevents double punishment. Applies to imprisonment, not fine alone. Why this section is important? Protects personal liberty. Ensures fairness in sentencing. Prevents prolonged incarceration. Upholds Article 21, right to life and liberty. In short, Section 294 mandates that any period of detention already undergone by the accused during investigation, inquiry, or trial must be set off against the term of imprisonment imposed after conviction. Section 295 sentence in cases of conviction for several offences. What this section is about. Section 295 explains how punishment is to be awarded when a person is convicted of more than one offence in the same trial. It deals with whether sentences should run one after another or at the same time. In simple English, when a person is convicted of 2 or more offences at one trial, the court may sentence him separately for each offence and decide whether the sentences shall run consecutively, one after another, or run concurrently at the same time. Important limit: the total punishment must not exceed the maximum punishment the court is legally allowed to impose. For magistrates, the combined sentence must stay within their sentencing powers. Key points of Section 295 applies when there are multiple convictions in one trial. Court has discretion to order consecutive or concurrent sentences. Each offence must have a separate sentence. Total punishment must be legally permissible. Prevents excessive or illegal sentencing. Why this section is important. Ensures clarity and fairness in sentencing. Prevents confusion in cases involving multiple offences. Allows courts to tailor punishment based on gravity of conduct. Protects accused from unlawful excess punishment. In short, Section 295 provides that when a person is convicted of multiple offences in one trial, the court may impose separate sentences and decide whether they run concurrently or consecutively, subject to legal limits. Section 296 sentence on person already undergoing imprisonment. What this section is about. Section 296 explains how a new sentence will operate when a person who is already in prison is convicted again in another case. In simple English, if a person is already undergoing a sentence of imprisonment and is convicted again and sentenced to further imprisonment, then the new sentence will normally start after the earlier sentence ends. Consecutive sentences. Exception: court's discretion. The court may order that the new sentence shall run concurrently with the previous sentence. This discretion is usually exercised when the offences are related or justice and fairness require concurrency. Special rule for life imprisonment. If a person already undergoing life imprisonment is sentenced again, the new sentence runs concurrently with the life sentence. Because life imprisonment lasts for the convict's entire natural life. Key points of Section 296 applies when accused is already in prison. Default rule: sentences run consecutively. Court may order concurrent sentences. Life imprisonment always runs concurrently. Ensures clarity in sentence execution. Why this section is important? Prevents confusion in multiple conviction cases. Gives courts flexibility to ensure just punishment. Avoids meaningless extension of life sentences. Maintains order and legality in prison administration. In short, Section 296 provides that when a person already undergoing imprisonment is again convicted, the new sentence normally begins after the earlier one ends, unless the court orders concurrent sentences. Sentences with life imprisonment run concurrently.